knowledge is causing your suffering and what you can do about it. This lawful process will give you ownership of your real estate. You will no longer be a tenant and can be completed in as little as a half an hour. This same lawful process will be used to secure your ownership of your real property and interest, known as your all capital letter name. It's the name of a landed estate, and we'll get to that in the future. But for now, let's talk about one thing that we can do something about today. Everyone who has a mortgage or deed of trust knows what it is. In real estate in the United States, a trust deed or deed of trust, is a deed wherein legal title and real property is transferred to a trustee, which holds it as security for a loan between the borrower and the lender. The borrower, you, is referred to as the trustor, while the lender is referred to as the beneficiary of the trust deed. Transactions involving trust deeds are normally structured so the lender gives the borrower, trustor, you, the money to buy the property, comma. The seller, the guy who has the property you want to buy, executes a grant deed, giving the property to the trustor, you. So what this is saying is that there is a grant deed, commonly known as a warranty deed, that is between the seller, on which this deed, he'll be known as the grantor, to the buyer, which is you, and you'll be known as the grantee. It doesn't have anybody else on it. There is no trustee. It's just a grantor and a grantee. It's a common law deed, and it's the very first piece of paper produced when you're doing property. So let's take a look at one. Okay, here's a warranty deed, state of Georgia, 29th of August, 2003. Between some group, hereinafter the grantor, and some person, hereinafter the grantee. The grantor, for said consideration of $10 and other good and valuable consideration, in hand, paid at time before the sealing and delivering of these presents, the receipt whereof is hereby acknowledged, has granted, bargained, sold, a lien conveyed and confirmed, and by these presents does grant, bargain, sell, a lien, convey, and confirm unto said grantee. So this says for $10, the grantor gave the grantee this property. And there it is. This deed is also given subject to all easements and restrictions of record, if any. To have and to hold the said tract parcel of land with all and singular rights, members and appurtenances, sorry, I can't say that word, thereof, to the same being belonging or in any way appertaining to the only proper use, benefit, and behoof of the said grantee forever in fee simple. Fee simple is ownership. You're not a tenant. You are now the owner. You have ownership rights. You have the right to use, right to enjoy, right to dispose of. You can never sell this house for more than $10. All that is fiction. We don't own the houses. They're owned by the Creator. They're His. He gave each of us an inheritance in land and tenements. Your land is your body. That's why you're the law of the land, and we'll find out how powerful it is shortly. But that's all He gave you. Everything else is public property. However, as a man, if there's an empty house or the one that you're in now, you can have ownership rights in it because you're a man. And this is how we're going to do it. So what you looked at was a warranty deed. A warranty deed is a type of deed where the grantor guarantees that he or she holds clear title to the piece of real estate and has the right to sell it to the grantee, to you. The guarantee is not limited to the time the grantor owned the property. It extends back to the property's origins. So he's telling you that it's warranted back to the date of the original land patent. So you don't need to get a land patent, you just need to deal with the warranty deed. Now, let's look at this again. So on here, on the right-hand side, is this the signature for the grantor. And then in the middle is a witness, and it was a notary. So this has the grantor on it and the notary. And that's how this was originally recorded. Okay. Well, because this notary doesn't have there's not another certificate saying that this notary is authorized to do this. Basically, it's called a certificate of authority. And it's just a short piece of paper that says, yeah, the notary's on file and can do this. And we'll look at one in just a second, what one looks like when you do it right. But this is how this was originally recorded into the Register of Deeds. So let's see what Bouvier has to say about to record. Sometimes questions arise as to when the act of recording is complete, as in the following case. A deed of real estate was acknowledged before the Register of Deeds and handed to him to be recorded. And at the same instant, a creditor of the grantor attached to the real estate. In this case, it was held the act of recording was incomplete without a certificate of acknowledgement, and wanting that, the attaching creditor had the preference. Now, before we go any further, the fact of an instrument being recorded is held to operate as constructive notice upon all subsequent later purchases of the real estate, legal or equitable, in the same property. So a properly recorded deed lets anybody else know ahead of time, hey, I'm the owner, you need to come talk to me. Your grant deed is first in line, first in time, goes back to the date of creation. And is good title. They only have marketable title, meaning it has a defect. The defect is the owner might someday come in and have acknowledged the certificate completed on his grant deed. And when you do, their title is worthless. You are no longer a tenant, you're the owner. So right now, with it the way it was, we'll look at it again in a second, but right now, but all conveyances and deeds which have been de facto, not lawful, recorded, are not to be considered as giving notice. In order to have this effect, the instrument must be such as are authorized to be recorded, and the registry must have been made in compliance with the law. Otherwise, the registry is to be treated as a mere nullity and will have no effect on subsequent purchases or encumbrance unless he has such actual notice as it would amount to a fraud. So, let's go back and look at this. Okay. So here we have a deed that the grantor has acknowledged. However, in common law, for a deed to be binding, both the grantor and the grantee have to agree. Well, I don't see anything on here that says anything about you. You didn't sign it. So what do? Well, if you want to acknowledge this deed and have it in fee simple as the owner, you need to acknowledge the deed. And I'm going to show you how easy that is. Just a second here. Let me pop this down. A certificate of acknowledgement. I, Linda Marie, the living woman in capacity of Linda Marie Bailey, am recorded as a grantee in the warranty grant deed of the real estate described in the attached certified copy of said deed. It is my free will act and deed to acknowledge my acceptance of the deed and lawful ownership of the property under the terms of the deed. I ask the record on file in the Office of the Register of Deeds to be updated to show my acceptance of the deed and the lawful owner of the real estate. This is my free will act and deed under my hand and seal. And Linda did it, and she decided to have another witness, which is fine with me. then your version of this at the bottom, this is called a acknowledgement certificate. And this one's for the state of Georgia, county of. On this, whatever day, before me, the subscriber, who the subscriber is going to be the notary, personally appeared Linda Marie Bailey, to me known to be a living woman described in and who executed the foregoing instrument and acknowledged before me that she executed the same as her free will act and deed. And the notary put her seal on it. That was easy. Any notary public can do this for you. All they're doing is acknowledging that you've come in and said you've done this of your free will act and deed. You were not coerced into this. And so this is a memorial to your free will act and deed. So this is the certificate of acknowledgement. And it's under the seal of a notary who is a judicial magistrate. They're a justice of the peace. And their seal can't be challenged by any court anywhere. However, we got to make sure that this notary is in the book as being a notary. Could be a forgery, could be a fraud. So how do we do that? Well, it's pretty simple too. In Michigan, you go to the county building. And in Georgia, it looks like it was the same, because this certificate is what they gave Linda, state of Georgia, county of Walton. I, Melissa J. Malcolm, Deputy Clerk of the Superior Court, Walton County, Georgia, the same being a court of record of the aforesaid county, having by law a seal, do hereby certify that Margaret Young, whose name is described in the foregoing affidavit, was at the time of taking said affidavit a notary public, duly commissioned and sworn, residing in said county, and was, as such, an officer of the said state, duly authorized by law, therefore, to take and certify the same, as well as to take and certify the proof and acknowledgement of deeds and other instruments in writing to be recorded in said state, and that full faith and credit are and ought to be given to her official acts. I further certify that I'm well acquainted with her handwriting and verily believe the signature in the foregoing affidavit is genuine signature. In witness whereof I hereunto set my hand and fix my seal. Now look at the seal you get. This is from the Superior Court, which is a court of record. And in law, under seal of a court of record is binding on all other courts around the world, period. The Supreme Court can't turn it over. So what you have done, without getting too deep into this subject, because this could take hours and hours and hours to explain to you, you're the tribunal of the court of record, a final jurisdiction of your sovereign nation state, of your land. Linda Marie Bailey is the tribunal of the court of record. And in a court of record, when you go to see a judicial magistrate, they're there merely to administer the orders of the tribunal. Well, here's Linda's order. The magistrate administered it, and one of their courts of record says it's due full faith and credit per the Constitution. So for anyone to go against this order, free will, act, and deed, whatever you want to call it, they would have to war with the Constitution. And that's treason. And that's a powerful tool. So this is how you end your nightmare. Do an acknowledgement similar to the one below. I've changed it slightly from the one that Linda did. That was my first swag at it, and I thought about it a little more, so I'm going to show you a different one. Linda, it's no big deal. If you hear this, you know, yours will be fine, but I just thought we should add something to it. Do an acknowledgement similar to the one below. Find a competent officer and have him, you know, speak these words. I wish to have this instrument of my free will act and deed acknowledged. You can use a notary public, a justice of the peace, etc. Many officers are considered competent officers. Just ask for one. You know, if you're in the courthouse, they're there. They may not call them a notary public. They may have another name, but they're called a competent officer. You just say, I need a competent officer to seal my acknowledgement. Find me one. Find out where you get a certificate of authority for the officer that just sealed your instrument. Here in Michigan, it's the county clerk. Some states may require you to go to the Secretary of State. At the end of the day, you want a certificate of authority, not an apostille. I don't know that they call it a certificate of authority, but what you want is you need to have the notaries or competent officers commissioned certified. This certificate of authority says that the officer that just witnessed your instrument under his seal has a commission to do so. So please don't ask me where to get the certificate from. Ask them. You know, don't be emailing me looking for an answer. Go find it. That's your job. If they balk and act dumb, act like a counter troll. Simply say, I accept your oath. Are you acknowledging that you are denying me due process? Do you know that is treason? If you're not, then go find out where I get this officer's commission certified. Now. If you are, then bring me your boss immediately on a bailiff because you're committing treason. So when you're successful, and you will be, take both the acknowledgement and certificate and head to the office where the real estate is recorded. Ask for a certified copy of the warranty deed. Remember, it only has two parties, the grantor and the grantee, the guy that sold it to you and you. If they act stupid, then ask to see the whole record and you'll show them what you need. Again, just you as the grantee. And it has a grantor. You do not want the deed of trust or the mortgage deed. When you are successful, and you will be, hand the clerk your acknowledgement, the certificate of authority, and the copy of the deed she just gave you, and tell her you want to record your acknowledgement of the deed, and get a few certified copies for your records. Congratulations. You are now the owner of your real estate, lawfully, and no longer the tenant. When they comply, and they will, you will now have good title to your property, first in line, first in time. So the marketable title being used now will be rendered null and void, as is anything attached as debt. You have good title, fee simple. When they record your instrument, the deed that was in the other file, where you got the certified copy out of when you walked in, it only has a marketable title. It doesn't have the other seals on it that yours now does. You have a record, a public record. This is a private record, what they have. So it's de facto. It's only de facto, not properly recorded. A marketable title has a defect. It is inferior to good title, which is why you need title insurance for a marketable title. Now that you've made it a lawful deed, also known as good title, and it's recorded in the Doomsday Book, which is in the Register of Deeds office. That's the book they put it in. It's one of its many names. Their marketable title no longer has any value. Anything attached to it in that old record is not your problem. That's why they have insurance. You own the property based on the original deed at its initial recording. Fee simple. So this is how I would change, what I call my acknowledgement. I don't own any land or property, so this isn't doing me a bit of good, but I can see that it could do a lot of people good. So you would have to change it too, and obviously you can see the parts you'd have to change. I, Robert Allen, the living man, created in the image of God, with indefeasible title to my land, and lawful owner of the landed estate known as Robert Allen Rutluski, and its real property and interests, under the seal, Robert Allen Rutluski, the way I would sign my name. I say that's my seal. They say it's a signature. I'm the law. They're the servant. I just told them what it was, and when you have this done, it will be the law. And recorded as the grantee on the warranty, grant deed, for the real estate described on the attached certified copy of said deed. It is my free will acted deed to execute this acknowledgement of my acceptance of the deed and lawful ownership of the property under the terms of the deed. I ask that the record on file in the office of the Register of Deeds be updated now to show my acceptance of the deed as lawful owner of the real estate. All of my other real property and interest attached to this real estate is to be immediately returned to me, done under my hand and seal of my own free will act and deed. And then this is the one for the state of Michigan. The important thing about doing these, you want to use some words that have substantive meaning, such as executed the same as his free will act and deed. It, everyone gets hung up in the word executor, and if they go to the next word down, where it's executory, executor with a Y, which says it's an instrument in waiting to be executed, you've just done it. You have just executed the deed to accept the deed. You've acknowledged it lawfully, and now it's under seal. And so when Linda gets a certified copy of this out, you'll notice this red sticker on the side. This isn't a certified copy like you normally get out. This is under the seal of the court of record. The clerk supervisor court, clerk superior court, Walton County. It's not the same as just getting a certified copy of a record that they normally have in there. And as you can see here, it was recorded under deed, not under miscellaneous or some other bullshit. No, it was put in under deed. And so now think about this. The deed that they handed you didn't go back to the same place it came out of. It went into another spot in a record book. And at the end of the day, title examiners come in and check all the books to see what's been put in the books. And when they see that, they're going to say, well, if this property is over here, what's in this file over here? The old file. It doesn't have a deed anymore. It's the only lawful piece of paperwork in there. Therefore, everything else in there is null and void at the moment. And so if anybody says anything to you after this, and I don't know that they will, but if they did, say, well, I have a public record that says I'm an owner. Where's yours? They don't have one. And in Blackstone's, he talks about the 7 types of civil courts. The very first one being trial by record. And the only defense in trial by record is to say that record doesn't exist. Well, sure it does. It's right here. It's recorded here. You have the record of where it's recorded. It's a public record. It's due form of law, guaranteed, full faith and credit, considered full proof, self-authenticating in any court case that you have. So if you're going through a foreclosure, go have this done, get a certified copy, go have it put in your court file. See what they do with that. And we'll find out soon enough, because that's where Linda was at. And as far as I know, Linda's the first one to do this. And high fives to her. She's leading the way out. Hopefully more are doing it today, but we'll find out. And once this is proven and evidence for those who need proof and evidence, then you will see how similar this process is that you just did for real estate will be for your real property and interest estate, known as your all capital letter name. We're going to go accept that deed also and have access to everything that's in your account. But we're going to have to leave that for another story. That's all I have for today. See you later.